I still got some people clicking on, but what we're going to do today is we're just going to touch on some things dealing with either ethics or some of the processes that we're going through, like escrow agreements, inspection reports coming soon, and some of those topics we're going to touch on briefly. And with that, I'm going to go ahead and hand it over to Shawn. She can start things out. Shawn, if you want to go ahead and get into the escrow agreement, talk about that a little bit.
Sure. Morning, everybody. We have a couple of things to review today. As George said, one of them is, and I know that we all are starting to see this one a little bit more when you're having a title company or somebody other than one of the real estate brokers hold the earnest money, which seems to be a trend that's picking up a little bit. And frankly, as a brokerage, we don't mind that. So that form, and all of you on the screen may be familiar, but I just want to clarify because there's a misconception about that form. When we use that form, the importance of the form, in case you're not familiar with it, is making sure that the title company or the entity holding the funds is agreeing to be subject to the same rules as a broker who would hold the funds. And that is that in the event of a dispute, nobody gets those funds until all parties agree, because a title company or other party is not going to be subject to the same laws as a real estate broker. So that form was put together by, it's funny because some of the title companies don't understand the form either, but it was jointly made up by Maryland Realtors along with MLTA, which is Maryland Land Title Association, kind of like our governing Maryland Realtors. So they got together to come up with this form that would be satisfactory to everybody, make everybody subject to the same laws, and protect the consumers. So minus that document, here's my theory on that document. Minus that document, if you don't have it signed, in my mind, the most damage can come to a seller. If you're representing the seller and everybody has not gone through and gotten that form signed, if there is a dispute, and if the buyer wants their earnest money back, and if the title company has not signed that form, that is the key thing. I see it a lot of times where the buyer and the seller both sign, and then that follow-up piece of having to get the title company to sign it is where we fall down a little bit, because we get busy running, you're doing home inspections, and you overlook it, but it's always going to bounce back to you on the required forms, because if it's not signed by them, and if there is a dispute, without that form signed, the title company could release it back to the buyer. And that could be harmful, especially to your seller client. I think personally, we wouldn't see that happen too much, because I think that if a title company did that once or twice and the word got around, frankly, I think it would be, I don't know if we have any title people on here, I think it would be career suicide to do that, because then any of the agents who might have been dealing with that title company might not see them as being entirely prudent and making good decisions. So I don't see it happening a lot, but the potential is there. That is what the form is for. It's not just a checks and balance to make sure they got the deposit in, which is still our responsibility to verify that they did get it, which is what the final signature on that form is. But it's also more importantly, or as importantly, to make sure that all parties acknowledge, most importantly, the title company, that they acknowledge they will be bound by the same rules and regulations, so that that earnest money can go to no one until everyone agrees. Does that make sense to everybody? We just have a sampling here of the company of agents, but that's one that sometimes it's still hard to focus on. We see that one come back a lot in the missing forms. So I thought I'd put it out there as we're seasoning through and using the form more. Hopefully that makes sense to everybody, and the why behind why you're always going to get that one back if it's not complete.
Yeah, and just to touch on that a little bit, Shawn, I know some of the issues that we've had is that that form is part of the contract, and we get calls from our agents that saying we're not getting the response. We're not getting that form back because your contract, when it's reviewed by our admins, they're going to kick it back if that form is not completed. And so it is up to you to follow through and make sure you get that. So it doesn't take that responsibility away from you. You still have the responsibility to make sure it's done. Even more so if you're the buyer's agent, because It's your buyer. But even as a listing agent, to make sure you get that back and it's completed. And I've pretty much muted everybody. So if you have a question, you'd have to unmute yourself or click and so forth, and or raise your hand, whatever.
I see Wayne just put a chat in. What's the liability? Good question, Rain. You always have good questions. What's the liability? I would say this to you. Because MLTA was involved in it, if we had an instance of a title, so far we haven't, but I see your question, it's valid. If you have resistance on a title company refusing to sign it, please let me know. Not that I'm more powerful or have more to do than you guys, but I would go directly to what I would do if faced with that would be to go to the title company owner or manager and give them the opportunity to understand the form the way I see it. And if they don't, then frankly, I would ask them to share with me who their underwriter is, because as a member of MLTA, I'm going to ask why their agent won't comply. So if we got that level of resistance, which hopefully we wouldn't, that would be the steps I would take. Whenever we have a problem with a title company, on occasion I get calls where an agent had settled, especially these days with fragmented settlements. I'll get a call from an agent, or they'll pop in my office where a settlement occurred 2 weeks ago and we haven't gotten the ALTA or the commission check yet. And then I'll typically make that phone call and advise them that they have till end of business the next day to have it FedExed here or delivered, whichever they prefer. Or if they're in a bind, they can let me know their underwriter and I'm happy to follow up with them. And then we typically get the check the next day, because that's like saying I'm going to tell the real estate commission, because that's who oversees
Shawn, Shawn, as a listing agent, would it be advisable for us to not use the form at all and to just say, hey, look, we want to hold the deposits?
You can certainly, yes, part of the negotiations of the offer. Yes, you could say, no, I don't, the seller is not comfortable. We've consulted. We don't want a title company to hold it. If your brokerage does not want to as the buyer's broker, then yeah, RE/MAX Advantage will hold it. You know, Alex and George and I have talked about moving away from holding deposits, but we always hit a brick wall on that one, because when we have our meetings, you know, if you all know Alex and love him like we do, they go 10 levels deep. So, and then we start to ponder the reasons why and why not. So certainly, Joe, that's something you could do if they don't want to hold it or can't, because some smaller brokerages may not have an escrow account. And you could say, no, as a point of negotiation, we want us to hold it.
And I think one of the other things to point out, and Shawn, correct me if I'm wrong, is many of your title companies, especially your smaller ones, that unlike us, that we're all part of boards and so forth, that we are updated with any new laws that take place. Not all of these small title companies are notified or updated. They should be. They should receive information, but they're not part of boards, so to speak. They don't get the same education. And when this first started kicking in, a lot of them were unaware that they were required to do this.
Well, and you make a point, George, because this form was co-authored by Maryland Realtors and Maryland Land Title Association, but not all title companies belong to Maryland Land Title Association. It's not mandatory. So if they were smaller and if they didn't pay attention or get the directives from their underwriters, because I feel the underwriters should have also been advising their agents, their title agents. The underwriters are, it's like if you have Allstate insurance, you have an accident, you might call your friend Bob, who's your insurance agent, but all he's going to do is take the report and give it to the main branch. That's kind of what the title underwriter is. They oversee and handle it if one of their agents does something wrong, or if they commit fraud, or if they go out of business. So that level of protection is there, and that's what the underwriter is and why that's my go-to. But you're right, George, not all title companies belong to Maryland Land Title. So sometimes it's us telling them about the form and why they need to comply, or why we want them to comply.
Yeah.
Shawn?
It's Ellen. Can I circle back about one thing you just said? Can you hear me?
Sure. Mhm.
So I've been waiting on several checks from title companies for closings that happened at the end of January, and people still don't have their checks. Are title companies obligated to FedEx or UPS those checks within 24 hours? 'Cause we're waiting on things that are coming snail mail.
Wow.
No, well,
Okay.
I would, I don't think there's any legal requirement for them to do that. If you were
Okay.
telling me that they were doing that with seller's checks, I might argue that we could consider it a dry settlement, which is illegal.
Okay.
Us getting paid may not fall into the same level. I think it's ridiculously stupid on
Yeah.
anybody's part to use snail mail these days. I mailed something in Linthicum December 4th that arrived in Glen Burnie December 26th. That's ridiculous. I
Yeah.
could have strapped it to the back of a drunk toddler and gotten it there faster. So if you're having those issues, if you want me to make a call, I know, Ellen, you're really good at getting things remedied and in line. You are very strong there in what you do for your gang in Baltimore. But if I can be of any help to you, let me know. I'm happy to follow up. And if, especially if they're little teeny title companies, maybe I understand it because they don't care so much to please us. But it's just with fraud and everything too, I would not be sending those kind of checks out through the mail.
Okay. Well, I'm going to circle back with both of those companies
Okay.
and see if I can get
Okay.
an update as to when it was done.
Okay.
One I know
Let me-
coming snail mail, but the
Let
other
me know-
one.
Yeah, let me know if I can help. We'll do a
Okay.
road trip and we'll go get the checks.
And I did send, while we're on the topic of title companies, I did send out 18 letters to title companies reiterating the fact that we are Remax Advantage and not Remax Preferred. So hopefully we'll get those
Get them to
files
stop doing
updated, and that won't happen
Yeah.
again.
Thank
So.
you, Ellen.
Sure. I mean, that was recently as last week. So
Okay. Yes,
Gina's
ma'am,
got a
Gina.
question.
Yes, I'd like to know where we can hire those drunk toddlers to strap things to.
Do you like want to put in an application? Because I know you have a little grandson. I mean, are you looking for work? Because it just is like the way my mind works. Sometimes stupid ideas come in there, and I thought literally I could have gone with a 2-year-old who can barely walk, and he would have gotten there faster. So, just
Yeah,
just
the
a
US
visual that came to mind.
U.S. Postal
Hey,
Service.
Gina, you're married to one of those drunk toddlers.
The Postal Service is running very slow. I know, just as an example, last week I still was receiving Christmas cards that were mailed, according to the people I spoke to, in early December. And
Yeah.
so it's really a mess. If you've got a settlement out there, I would strongly recommend that you follow up, even at settlement. Talk to them how that's going to be handled. Talk to them on the phone. Are they going to FedEx it? And you can request that. Ask them, emphasize we need to get that as soon as possible because it can get lost in the mail.
And it would be, it's smart business for any title company to say, yes, of course we'll do that, because they should care what you think of them at the end of the day. But anybody who's having a settlement and you're dealing with somebody who won't do that, don't forget, and I don't mean you should have to incur expense, but if you don't trust the postal system like I don't trust it, and that's not a conspiracy theory, I just don't, we have evidence. But if you want to ever know, any one of you, your admin in your office should know, or you can ask me, you could give them our FedEx number and they can send it to you under that. You'll get billed for it, but it's an alternative if you're not going to settlement and they're refusing to do it, which is poor business practice. But there's another alternative too, just to put that out there for you.
And we have had some wiring that we've done, but you got to get the wiring instructions from Michelle McGuire, either her or you get them from Karen Welsh out of the Fulton office, and they will give you the wiring instructions so they could wire. And then I haven't known of recently, I haven't known of any of the title companies that have charged you for any wiring. or anything.
Right. And right now, M&T, our bank, is still not. Last I checked with Michelle a couple of weeks ago, or actually I just had a buyer client wire in an EMD. M&T has not reinstituted. They were, before COVID, charging us if we had a commission wired in or an earnest money wired in, they would hit us with a fee. When COVID hit, Leslie worked with them to get those waived. And so far, they have not reinstituted them. I guess because we're still in COVID, but I don't mean to sound stupid there, but I thought maybe it would be a limited time. It is still ongoing. So that is another alternative. But like George said, again, be careful because of wire fraud. We've had a few of those happen, and verify instructions with everybody and make sure you get them directly from Michelle.
Yeah. Okay.
Enough on that form. Are we good?
I think so. You want to move on to the inspections report?
Okay. One that happened recently that I'll share with you guys, and it may never have happened, but just to keep in mind, when you're negotiating a property inspection report and you represent the buyer and you're putting forth the request for repairs, a couple of things to touch on that form, some pushback that I'm told by some of you guys that we get. One that we just recently had, and we've probably all worked with agents like this, the kind, I call them lure you into the hole agents. They see something not happening right. They believe if they don't work cooperatively with you to fix it, that it will benefit their clients. So they allow you to get pulled into that situation. And we had one just recently where in negotiating the property inspections report, there was some breakdown in communication between the listing agent and our agent who represented the buyer, with some things going on. And the property inspection notice was sent over with a request for repairs. The seller said no to some. The buyer then said, okay, based on the outline of this document, then I'm going to not accept your answer and I'm going to cancel the contract. I'd like my deposit back, please. To which the answer was, seller's not given the deposit back. You did not conform to the agreement. You did not send the entire home inspection report. And I even tried to talk to the broker about it, who would not take my calls. Just, there was really no defense. I thought maybe we could make logic of the situation, because it was evident that the listing agent was making a point, feeling that she was somehow giving her seller a leg up. And ultimately, I think it wound up our buyer losing half of their deposit to stop the fight, because the seller would not sign the release of deposit. The buyer did not want to give it all up. And I think I had spoken with our agent. I think they negotiated halvesies, but it was a $3,000 deposit. And so halvesies was $1,500 in that case. And it was based on an I gotcha moment. In my opinion, I think it was yucky. I think we all have to work together at the end of the day. And I got the distinct feeling that it wasn't the seller interpreting that. It was not and I don't mean to sound, it was not a sophisticated transaction. I believe, based on the emails that were shared with me from the listing agent, that she encouraged that behavior from the seller. And that's what happened, because the entire report was not submitted. So it could happen. You get busy, you send the request for repairs over, everybody seems like they're negotiating on it, when actually at the end of the day, if it doesn't work out, the other side is going to say you didn't fulfill your part of the agreement, and so we're not going to readily let go of that deposit. That's one to watch.
In many cases, these agents look for loopholes like that. I mean, and we went over something about a week ago where we discussed the as-is addendum, and there are agents that are using that, and in some ways, I would say in some ways it's sort of misleading, because they're in a very competitive situation. They're using the as-is addendum, but then they still come back and ask for repairs. And when you use an as-is, you don't have the same outlines or requirements, timeframes, and stuff like that as you do with the regular, whether it's the RMA or the MAR inspections addendum. It doesn't have the same outlines and timeframes and all that for people to respond to. So it's, be careful what you use. And if you deal with anything out of our jurisdiction, any of you that go into Montgomery County, PG County, understand that their addendums down there will differ from our MAR addendums by the timeframes. The Prince George's County addendum has a deadline, like all of our deadlines on our contingencies are basically 11:59.59 p.m. After that, it expires. In Prince George's County, it expires at 4 p.m. In the GCAR addendum, it expires at 6 p.m. So you got, and the way it goes back and forth differs. So be careful what addendums you use or
Right.
that are used in any offers that come to you.
Right, if you receive one. And the GCAR, one of the key elements too, any of you who use it hopefully are aware of it, but the GCAR is polar opposite of the MAR in that with the negotiation of repairs in the Maryland Realtors contract, a lack of response indicates a no. On GCAR, a lack of response indicates you accepted what the person said right before you.
Yep.
So if somebody says, I want you to fix 24 things, and you miss your deadline to say, I'll do 5, but not all 24, you miss your deadline, you just agreed to do all 24. So it's opposite the Maryland Realtors. And we had somebody get in a pickle over that one time. That was tough because the missing of a deadline is critical. It's sometimes, I think, why you see, I don't do much business down in the places that use GCAR, but I think it's sometimes why we see agents want the offers to come in on the documents that they're familiar with, because they're familiar and they're not so afraid of missing something. So just if you're working on a contract or addenda other than you are familiar with, just like George said, be so careful in interpreting and reading what you're getting, because don't assume all are the same. That GCAR is so vastly different on the responses on those repairs. You can say yes to a list this long with having no intention to.
Any more questions regarding the inspections? All right, we'll move on. I am still getting.
Hey, George,
Yes,
George,
sir.
I have one. Just, can you go over the as-is addendum again? Because, you know, agents are asking for repairs, but if it's an as-is and there are repairs, they still have an out of the contract, isn't that correct?
That is correct. They still have the right
Okay.
to do that. There's nothing that says that they can't ask for repairs. There's nothing at all that says that they can't.
Okay,
I
okay.
think
I just wanted to confirm that.
Yes, some buyers agents are using it, and I truly believe that some agents are doing it. I hate to think nasty of agents, but some agents are using it thinking that the seller is thinking that, okay, I'm selling my house as is, I'm good.
Yeah.
It's important that you explain to your seller, if you're the listing agent, that yeah, this is an as is demo. They could still come back and ask for repairs. They have a right to get out
That's
of
a
the contract.
good point, George. Good point, George. Thank you.
Okay, and know that you got to look at, again, at the different addendums, but it states in there that it basically, it eliminates the pest inspection and it eliminates the transfer of property, the condition of property when it transfers. It eliminates those two clauses within the contract. Okay, but the point is that they can still ask for repairs. But if you don't explain that to your seller may be thinking, I'm selling it as is, I don't have to do anything. That's not true. It's misleading.
Hey, George,
Yes.
question is, you care a good point. As is addendum states that no repairs to be done by the seller, which you did hit on some points. You're talking about the termite inspection. It could be a radon inspection. It could be a chimney inspection. It could be any inspections that are in their contracts saying that they're not obligated to do any of that.
They're never obligated to do any repairs. They're never obligated, but your clients always have a right to get out if they don't. With the as-is addendum, you're basically saying you can do any inspection. If you'll notice, even in the as-is addendum, it doesn't even say that you have to have a certified home inspector. It just says that the buyer has a right to inspect, that they can inspect, they can do anything. But as Shawn, I'm sure, will say also, is if you're going to do something additional like a radon, you're going to do something different like a well or septic, it is strongly advised that you use, along with that as-is, addendum, one of those addendums, because there's certain language in there that protects anything, say for instance, like a septic, any excavation or anything like that, it protects the person that's doing that inspection.
Well, that's a good point, because in our well and septic and the termite, basically, if you put that into the contract, that as is should not be affected by these things being done. But is that a conflict, because you're saying you're buying a house as is? Does the septic and well and the termite override that?
You're allowed to do any inspections. The as-is addendum gives you a right to inspect. You can do anything. You can do any inspections, and you have a right to get out of the contract as a result of that. So it doesn't, and I'm not saying it overrides it, it's part of it. You make it part of it. It's just more defining an inspection that you're doing, and there's a little bit more protection in there for the inspector, and it's more of an outline as to what's involved with the inspection.
Yeah, because the termite inspection would automatically override as is in our contract, I would think.
It does not, because if you read the top language in the top part of that as is, it says that that article is basically eliminated.
So if, but
So
in our
that 2% that you're normally agreeing that you'll remediate and make repairs up to 2% of the contract sales price, that's overridden by the as-is addendum. But you can still ask for it. It doesn't mean you can't ask for it.
Yeah, but they can still say no, and you're
They
still
can.
obligated to buy the house.
Right. So in that case, that particular case, you're right. They can say no, and you have a right to get out of the contract. But there's nothing obligating them to do that particular service or that remediation, like the article does. Article 9.
But you got to follow the time, as you say, as is. There's a time period in there. You have to make,
yeah, it's usually 10 or 15 days. Most of the time, I see 10 days in there that people put in there, and be careful with that. Make sure that you can complete it within that time frame.
Hey, George.
Yes.
This is Eric.
Eric.
What I've done for as is for termites,
Mm-hmm.
I will write on the actual addendum, except for cellar treatment of termites, this is as is. So basically, you could write in an exception that termites are still covered, but you have to write it in and cross out that line that says termites are not. That's what I've done in the past.
Yeah, you can do that. Remember, and be careful what you write and how you write, because we're not attorneys. But just know that anything that if you write something in there and they agree to that, that's an agreement. That's part of your contract. That's part of the agreement. But also, Eric, what I would do is, if that clause is in the top portion, I would even probably scratch that out.
Yeah, I do. Yeah,
okay.
I do that as well.
An initial next to it.
Yes, exactly.
Okay. Makes sense?
but what you're saying is that with the addendums, like the well and septic and the termite, we put an addendum in there saying we want to have the test done, and if they call back and fail, then before the time period is up on that as is, we can get out of the contract.
Yes. Yeah, you can get out of the contract for anything any inspection you do per the as-is addendum, providing it's done within that time period. That includes withdrawing out of the contract. So if you've got 10 days in there and the 11th day rolls around and you decide you're going to withdraw because they're not going to make a repair, you're bound to the contract now, because your period has expired.
That as is such a dangerous addendum when you're involved in that thing.
It can be.
Against it.
Hey, George.
Yes.
Hey guys, this is Vince. One of the things that we have been doing, and this is pretty much like what I'm seeing is every doggone agent out there for the last year, using these as-is addendums. I have to be honest, the as-is addendums have turned into BS addendums. Mm-hmm. They really have.
Yep.
They're complete BS anymore. And, I don't mean that in a nasty way. They just are. When I talk to my sellers about accepting an as-is addendum, I explain to my sellers, look, that buyer has X amount of days to do any inspection they want to on that property, any. any.
Mhm.
And, you know, if it says 10 days, whatever that time frame is, usually people put 10 days. So they have, you know, I tell my sellers, they can do any inspection they want. You got to remember, they can walk away. They don't have to ask us to do anything. They don't have to do,
That's correct.
they can just walk. So I make sure my seller understands that. But I also explain to them, you know, hey, if this is going to happen, I will open up a dialogue. You know, keep in mind, do you want to lose the sale, or do you want me to find out why? I will open up a dialogue. Hey, why is your buyer walking? What's, you know, is this something really, really bad? Like, would they walk if it wasn't as is? What's the scoop? And 9 times out of 10, it's not. I mean, it could be something that's a couple $1,000. It could be something that might be $15,000. But at least I still want to find out, hey, is your buyer still willing to buy this house? If my seller takes care of this, we get it as is, and we might let you walk, but would your buyer still want to buy it? Well, if the answer is yes, I at least go back to my seller. And I've done that several times. And my seller was like, well, I don't want to go through this rodeo again. You know, I agree with them. Tell them to send me over the inspection. Let me see it. Oh my God, I didn't know that whatever XYZ was going on. Of course I'll fix that. Or will they take a credit? So then we make it work. I also explain the exact same thing up front to my buyers. You know, I say, look, we are agreeing to this as is. You don't have to do anything, but if we don't put it in as is, we're probably not going to get chosen out of the 7 offers that they're looking through or whatever. You know, they've told us there's multiples. It could be 2, that could be 20. So, you know, I explained to my buyer, if you want to go not as is, that's fine. We'll write it up, send it over, see what they say. Usually they don't. They choose to go as is. And I explained to them the same exact thing, but in reverse order, that, hey, we've got these 10 days, whatever we put in, to do any and every inspection you want to. Let's make sure we have it all done well before the 10 days. So you have the, you know, right to refuse and walk away, because we don't want to miss that timeline. And I explain it to them, but I also tell them, you know, if there is nothing, you've got to expect minor things. You have to. You got to expect a GFI here or there. You've got to expect, you know, if it's a few piddly things that might cost you $1,000, are you going to lose the house for that? They always say no. And I'm like, cool. So then they know we're not beating this seller up on minor things, but if it's something that is major, whatever they feel is major, then we can always open up a dialogue, but the seller can just say, nope, walk away. But that circles back around. It really has turned into BS. It's a big feel good for that seller and get you, you know, maybe your foot in the door to be able to win out these multiple offers, but you're still right back to the drawing board unless there's nothing major wrong with the house.
Yeah, it's good points, Vince. I mean, you know, the sign of a good agent is we all represent our clients and look out for the wants, needs, and desires of our clients. But also the sign of a good agent is somebody that is confronted with issues and they find a way to resolve it and keep the contract together. Because let's face it, at the end of the day, a buyer wants a buy and a seller wants a sell, and we make that happen. That's not saying that, you know, it's always up to your buyer or your client, and it's always up to your seller or your client. It's their decision, but we can explain things to them. I can make this work if you'd like me to do that. This is what we can do to keep this together. Because if you really want this house, we can make it work. I've talked to some agents in the past within our company, and I'm amazed sometimes how well they negotiate these issues that pop up, and they work through it. I always look at it when another agent is involved in a transaction with me, they become my new best friend. I try to work through it. I don't hate them. They're a partner in this. I still have to represent my client, and I have to do what's best for my client. But I try to make it happen. But everything goes through my client. Everything goes through them. There's too many agents out there that will do things, and I know they're doing it without going to their client. Shawn, it looks like you might have been wanting to say something.
I was just agreeing with both you and Vince. I agree wholeheartedly. I prep any seller client for, we really probably would prefer that they do ask you rather than walk away. So just be prepared. Don't be insulted and start yelling at me. It's as is, it's as is. Do you want to slam the door or do you want to have communication? And as you were saying, George, yeah, you can think that other agent is the biggest bozo on the planet, but instead of making that an impediment to negotiating through this, like you said, never to the detriment of your client, but the better we can all get along within the transaction, that is serving our client the best. You don't betray your client and take away from them to do that. You don't, subvert them or something, but you, by getting along with the other agent and keeping negotiations open, you are achieving your client's goals.
Yes.
Aren't some things that come up in those inspections, at some point, it's going to be a disclosure for that seller as well.
Yes.
So, I mean, you've got an active and wanting party to buy your home. So isn't it really in your best interest? Because even if these folks walk, the next buyer that comes out, they're going to know, I mean, you have to disclose that. So, you either drop the price or you're doing something. So,
Yeah, I agree with you, Ellen. Absolutely.
One question I had on that was brought up is that, for example, if you ask them to do repairs on the house and you have it as is addendum, you get a time frame and you send it over and the seller says, well, let me see what the contract is, how much it's going to cost me. And it might take 5 days for them to get somebody out to take a look at it. Now you're going past that time that you can withdraw from the contract. That becomes a problem, I think.
So then what do? You ask for
terms.
you write up an extension.
You can, but again, if they don't do the extension, then you're going to have to withdraw the contract.
That's correct. Okay.
But a lot of these, that's the problem. These, like well, in septics, sometimes they take 30 days to get done, 25 days to get those things done.
Oh yeah. So that's why you've got to make sure that the time frames that you put in there, like any time frame you put in any part of your contract, has to be something that is workable. I've seen contracts where you have a loan commitment period that is outside of the settlement date. I mean, you see these things all the time. It's something that you as an agent, it's important that you pay attention to that you review that contract. There's another thing and there's nothing wrong with it. So don't shoot me when I say this. There's another thing I don't like that I've seen a lot of recently, and that's in the MAR inspection addendum, Article 2G. 2G is basically, it doesn't have a particular inspection in there. And they'll write in there anything the home inspector feels or deems necessary, or any other inspection the home inspector deems necessary. I don't like that, because I want my seller to understand exactly what they're agreeing to. What does that mean? What other inspections are there? I don't know. That doesn't mean they're wrong in asking for that, but I want something specific. I want to know what other inspections could there be, and they might say, I don't know. Anything they ask for, you've got an open book. So in my mind, and Shawn may shut me down on this, but in my mind is, do you really have an agreement? I don't know. I'm not an attorney, but I like specifics. I want my client to know exactly what they are agreeing to. And that's just my opinion. That doesn't mean they're wrong in doing that, but that's my opinion.
But George, that's a good point, because you're right. You're opening up to any inspection that somebody says.
Yes.
And then you're like, and then how much time do I need for that?
Mm-hmm. Exactly. Yeah. Okay.
Hey, George, going back to the as is, like that extension thing. Mm-hmm. I'm sure most of us have probably had to do that. I know I have. What I always try my best to do is when I extend that, I won't specify and go into too much verbiage on exactly what we're doing. I will just talk to the other agent and say, hey, because your seller needs, through whatever, the 13th to get these estimates, let's just extend that as is addendum through the 13th. So everyone is on the same page, and they'll usually agree to that, and I will simply do it that way. So I'm not changing any basis of the contract. It's simply extending that as is addendum through X date. So everybody is on the same page, and that usually works.
Mm-hmm.
Yes, yeah. But always understand, Vince, anything we do has to be in writing. You can agree with something to somebody voicemail, but that may be between you and the agent, but it has to be in writing so that it is enforceable.
Oh, yes. Yeah, always in writing, but I extend that as is addendum.
Okay.
I don't take it and say, well, the seller has X days to get an estimate for a roof or something like that, because that could be misconstrued. And if that seller comes back, gets that estimate and says, I'm not fixing this, and now the buyer says, well, I want to walk away, they very well could say, well, wait a minute, you never extended that. Your time's out to walk away. So I simply extend that as is addendum, so I know that I am within that time frame, and it's within my buyer's right to cancel.
Yeah, got it. And that goes back, and I'll say this one last thing, Jerry, and you brought up a good point. If you're using other addendums, such as well or septic, make sure that those times fall within the time frame, the as is, because if you got 10 days there, and on those addendums you got 15 days, you might be taking away your right to cancel the contract. So make sure you have that additional time in the as is addendum as well. Okay, just so there's no confusion that comes up, no disputes. That's our whole point, is just trying to keep down the disputes. Make sure everybody's aware of everything that's going on, so you minimize your disputes and you have a smooth transaction. Okay, I'm going to move on, and I want to talk a little bit. Somebody just tried to call me again, and decline. I'm going to do that. Okay, I'm back into this, so I'm back online here. Okay, so I want to talk briefly about coming soon, because I still get questions about that, believe it or not. Coming soon is a bright MLS thing. Okay. And basically the rules of coming soon are, if your property is coming soon, you are not allowed to mass market it. You're not allowed to show it. Okay. It is the purpose of the coming soon is for a seller to be able to prepare their home for when it goes on the market. In contradiction to that, you can, believe it or not, accept a contract or accept offers on it. You can do that. Okay. And when it comes to offers, remember, we anytime we receive an offer, and this is also something that comes up periodically. I get a lot of agents that call me and complain about this, that offers are submitted by you, the buyer's agent. It goes over to the seller's agent, and the seller's agent doesn't respond, doesn't acknowledge. They're hard to reach, and I get complaints about that. What do I do? You're up. The NAR ethics basically say that you are supposed to get with your seller as soon as possible and submit every offer to them up to and including the day of settlement. And that includes leases. Any lease you might have, you're supposed to present all offers up to the time of settlement. Okay. But it's ethical and it's professional to get back to those that submit that offer to you in a timely fashion. We've got agents that will not respond. And what do? There's nothing that outlines that says you have any recourse against them other than telling your client, you're tired of waiting, withdraw your offer. But I don't want to wait. I want to respond. There's not much we can do, unfortunately, unless somebody knows a better rule. But there's nothing, Shawn and I have talked about this. There's not much else you can do other than threaten to withdraw, or even as you're submitting, you can put something in there basically saying that you request a response within X number of time, 24 hours, 12 hours, whatever it might be. And if they do not respond at that time, this offer becomes null and void. Any questions with any of that? That was a real quick one to go over.
Yeah, George, real quick, I had a question on that. So basically, you got it coming soon. They don't look and see the house. They just write up a contract and submit it. So if they get it accepted. Mm-hmm. And as a listing agent, we're obligated to obviously submit the contract to the buyer, to the seller, and the seller can decide if they want to accept it or not accept it. Mm-hmm. But the seller can also say, I'm not accepting any offers until it comes on the market.
That's correct. But make sure that they give you something like that, anything, and it can be in an email, unless Shawn tells me different. You want something in writing from them saying that they don't want to accept any offers. And that even includes if they go under contract, if they don't want to accept any more offers, have them send you something in writing stating that. Okay?
Hmm.
Hey, George, is there
Yes.
anything that says that we can't talk to our buyers in a situation like that where we've got another agent that's not presenting it and say, look, I can't do this, but if you want to, you can go over to the house and knock on the door and say, hey, look, my agent's been trying to present an offer. Is there anything wrong with that?
I think that's pushing it a little bit. But I see Shawn
But in
thinking
what
like
way is it? But in what way is it pushing? Is it against the code of ethics? Are we violating a law, or is it just being a pushy good agent?
well, it feels to me that I'm almost finding out of going behind the listing agent and being able to get in and contact their seller. But if your buyer takes it upon themselves without your instruction to do it, and they knock on the door, I'm not sure I have any recourse with that. And Shawn, go ahead. I can see
Yeah,
your mind turning.
yeah, I wouldn't, yeah, there was smoke a little bit coming out, but I wouldn't have that open conversation with a buyer client, for a lot of reasons. And again, I have a mind that just goes like with all the what ifs. I'm like, if I tell them to go over there and not knowing
No,
the
I'm not.
circumstances of the seller, I'm sorry, go ahead.
I'm not saying that I'm telling them to go over. I'm just saying, look, I can't do it, but there's nothing stopping you.
I would not have that conversation at all with my client because the way life rolls, you maybe have that incidental conversation and they go over there and unbeknownst to anybody, I mean, this is extreme, but unbeknownst to number one, it might be subversive, but number two, what if they go over there and you have a volatile situation where none of us know it, but the listing agent does, and you've got a husband and wife divorcing, and you happen to catch the volatile one at home, and your client knocks on the door, and it goes all ways of ugly. And so that's like the extreme, but I wouldn't participate in that conversation. I wouldn't love it if my client did it anyway. But it's almost like I wouldn't have that conversation because it's almost like going down the path of there's a big topic out now about these love letters, like participating in them and encouraging them or allowing them and giving them to the other side. I wouldn't have a conversation with a client that involves them bumping into the seller and saying something about an offer.
Yeah, and to me, it almost, even though you're not instructing them to do it, Joe, it almost sounds like you're okaying it because let's face it, if the listing agent now calls you and says, you know, what's going on? Your buyers just went over to the seller's house. They're knocking on the door. They're harassing my seller, you know, and all of a sudden you say, yeah, they told me they were going to do it. Now that sounds like you acknowledged it. You okayed it. Be very, very careful with that because anybody can turn anything. And I've learned a lot of this, and we're going to be getting into ethics, a little bit of ethics in a few seconds. But I'm telling you, the classes I'm renewing my DC license, and I've gone through, out of my 5 classes I've taken, 3 of them have dealt with fair housing, dealing with people, and it's amazing going through the scenarios that they're giving that the agent had they did not feel they were instructing this, but it was interpreted as that, and they were still held accountable. Okay. See, Jay's asking a question here. Let me see what Jay has. Question. The one COVID seller addendum signed by seller has caused a problem. One of the sellers lost out on the next home when the buyer could not settle on a contract date. Bad. Jay, why don't you explain a little bit what you're talking about there?
I think there's 2 seller addendums as option to work with any listing and as a disclosure to any buyer through MBAI. And the COVID addenda, if the seller signs the one that says they have so many days to, because of COVID, they have so many days to rectify the problem. And that really caused a problem because the buyer could not settle because they did not qualify to purchase it at that time. So the seller ended up losing out on their next home of choice because of this override of the so many days of the COVID addendum.
I have a thought, and I get your question, Jay. Let me ask, maybe I'm misunderstanding. Even minus the addendum, though, the buyer would not have been able to settle on time, right?
Right.
So it gave the buyer, I guess, more time to be able to perform, but that
Correct.
seller would have still lost their other home.
Correct.
Is your question meaning like, but they had to still allow that buyer to try to perform, and now they don't have a home of choice? Is that what I'm understanding?
That is correct.
Hmm.
And we had backup offers.
Okay.
My question on that is, how can you use a COVID addendum when you're talking about selling a house contingent on the other house settling? Because just what you said, if that addendum goes into effect, that's going to screw up the other deal.
Uh, you're correct, Jerry.
And so I wouldn't use it.
I'm never using it again.
Now, the other problem, I mean, when the situation comes up and they can't settle, I guess you try to work it out if you can. But I just can't see how you use a COVID-19 addendum on a contingency on buying another house. It just doesn't make sense. I mean, correct me if I'm wrong on that, you guys.
No, I'm still thinking through that. There's a lot of thought going there, and I can see Shawn's thinking a lot too.
You can't use it, I don't think. It's no way. Because
I will never use it again.
Because you're automatically putting 2 weeks extension onto a contract that, hey, Mr. Seller, you may not settle on your house because, the people may not give you an extension and they're going to sell it to somebody else.
Got it. Okay. I don't know. What are you're thinking a lot, Shawn?
So Jay, your seller, okay, so your seller's buyer couldn't perform because of COVID, thought maybe they could still pull it together in a couple of weeks or whatever that extension was.
Well, it wasn't because of COVID. It was because the buyer actually could not afford, it did not have the loan commitment and could not afford to buy, but we're still willing to continue on, and that COVID addendum allowed them to.
Wait a minute. I'm getting confused. If somewhere along the line, somebody was told that they couldn't afford, they were turned down for the mortgage, correct?
Yes.
So how did the COVID cause it?
The COVID addenda was already one of the disclosures and signed by everyone, but both parties.
But it was really that the buyer just couldn't afford the house. They couldn't get.
Well, the buyer still continued, and they ended up still. They ended up that they could qualify finally. I don't know how, but anyhow, it was a process. I'm not telling everything, but the buyer was finally able to go proceed. But then at that time, our seller clients had already lost out on their next home.
Yeah. See, but it's still like Shawn's saying, it sounds more to me that it wasn't the COVID that caused the delay. It was their failure to be able to obtain a loan. And that's a
correct
situation. And they were using the COVID addendum to do that.
To extend, even though the contract date wasn't extended.
But the COVID situation is what caused the extension. So it shouldn't even come into play.
Yeah, you're right.
That sounds like a manipulation of that addendum.
Yes.
What they should have done is to extend the financing program for 2 more weeks. Forget the COVID, but extend the financing for 2 weeks and tell the sellers, can you extend your contract for 2 weeks? Because their contract is contingent on settlement on that property.
Yeah, they used that.
They could have lost out on that house too, because they could have came back and said, can I get extend the contract? And if they'd extended on the other house, then they would come back and say, well, we lost our house. Now we had to go find another one. So you guys got to wait till me find another house.
Yeah, I think they misused that COVID addendum in my mind. Mm-hmm. They abused it. Let's put it that way. That shouldn't even come into play. because it wasn't caused, the delay was not caused by COVID. That addendum was meant that if for any reason, say for instance, the bank had to shut down for some reason for a few days because they had an outbreak, something like that, that's COVID related. Okay.
I had one that was legitimate. I had a nurse client who, when COVID began, left her hospital that she worked at in North Carolina, went to Ground Zero in New York to be an ER ICU nurse to help when they were overrun. And that created, believe it or not, a gap in her employment because she went on leave from this hospital and went to whatever the mass was up there. And at the end, it created a delay in the settlement. We worked it out, but that was like a legitimate COVID delay. Did your seller clients sell to that buyer, Jay, and then just not have a home, or what happened?
No, they took the house off the market and they aren't going to sell. They, I think, are building or adding on to the house that we had listed.
Oh, wow. Okay.
Well, dang.
I have some issues with that whole thing, the way
Yeah.
that went down, but we can discuss that later, but I have issues with the way that went down.
It was reviewed by Ted.
Okay. Just again, we all have opinions, and I have issues with it.
Yeah,
That's okay.
such a gray area. Yeah.
Yeah.
I'm sorry.
I want to finish out this session with some changes in ethics and some things that are going on with the NAR ethics, code of ethics, especially in today's world with the division that we are seeing within our society. I have seen it myself where agents post things on the social media. There is hate language in there. I've seen agents display it in pictures. I've seen it in multiple ways. There are now conditions under the NAR Code of Ethics prohibiting any kind of hate information that goes on social media. And I know Shawn's got some thoughts on this as well, but we have to understand that we are professionals and we're not trying to take away anybody's freedom of speech. We're not doing that, but we are professionals and understand that you represent the industry, you represent the company. Anything you do on social media, it can be tracked back to you, can be tracked back to us. And I stay out of the politics. I'm like anybody else. I have feelings about it. I have opinions about it. I don't post anything on social media about my political stance or my stance about anything dealing with that, because I think it reflects on me as a professional. You wouldn't go into your doctor and your doctor's going to sit there and talk to you about how he hates this candidate or that candidate, because that's not what you do when you walk into a doctor's office. We're no different. And Shawn, if you want to kick in here for a few minutes and talk about it.
We actually had, believe it or not, in the thick of it, one of our agents here, whose accountant that she's had for over 10 years, fired her because her political views differed from his. That was extreme. And that accountant was known to this company. So anyway, I agree with George. I am, I guess, what you'd call a Facebook stalker. I watch other things. I stay in touch with my group of 50 or so cousins, and we share family goings on. And I observe things, but I don't put my opinions out there. I don't when I'm working with clients. Most of you are probably the same way. It doesn't belong there. And as George said, these days, it's not even sometimes a difference of opinion. It can become a dangerous and incited, fueled situation where people, I think it's just such a perfect storm of everything in our lives these days. If you think about this year, there's nothing funny about it at all, but it is a ridiculous comedy of errors what has transpired in this year. And I think everybody is so heightened, and so, we all have our moments where we're dealing, and then something hits you which may be arbitrary to the whole situation, but you're ignited. And that's probably the worst time to get on and put your opinion anywhere, because it may not even be a true representation of who you are. In the moment, you feel better. But I always joke that literally, if I showed you with my camera, the backspace key on my keyboard is the most worn out key on the entire keyboard, because I feel like this and I type it and then I back up or I delete it before, God help me, it gets sent somewhere. But as George said, it's now, I mean, the code of ethics is the code of ethics, but based on what's been happening out in society, in November, they revised it to include this kind of hate speech and inciting things on public media that is an actionable item. And then they tie it further into, if you're doing that, depending on what you're saying, besides ethics and inciting other people, you may actually be demonstrating some fair housing, breaking of fair housing rules, because what you're saying may demonstrate that you may not want to work with a certain group of people. And if somehow they fall into a protected class, which are now what, up to 112? I'm kidding, but if you do that, you've taken it from a new level of just an ethics complaint, which once it runs through your local board, if it's agent to agent, it runs through your board. Now that has to be reported to the real estate commission, and they keep track. And I was talking to George earlier, it's like getting a speeding ticket. Speeding ticket number 1, the judge looks at you, sees no record, gives you a fine. Speeding ticket number 4, now you are pathological with it. You are doing it, it's a thing, you have no regard, and your fine and your punishment is going to be different. And that's how these things are now going to be. They're not looking to punish, because all of us can make innocent mistakes. We don't mean it, or we might say something, or somebody takes something we said wrong because you didn't even say it in a mean or vengeful way. And a lot of the frequently asked questions that I read said, well, could somebody ruin me in my career because they accuse me of doing something? There's still due process. You still have to go through an ethics hearing. And if in that ethics hearing, it's discovered that you unintentionally did something, there might be a reprimand. There might be a 3-hour class on ethics. If you become habitual and it's noted and they're watching, you could potentially be in trouble. And people bring up, well, about free speech. It's true. NAR is not trying, nor do they have the right or the means to enforce or deny anybody's rights under the Constitution, but they are a private group. And to be a member of that private group, they can put forth the guidelines under which you can be a member. So they could deny your membership. And if you do it enough and the local boards don't report it, they can then deny that board membership, which means every agent who is a member of that local board, be it Anne Arundel County, HCAR, whatever, if it got that crazy and that board is compelled now to keep track and report this, if they don't, they can be excused from membership in the NAR, which affects all of your coworkers out there in the industry. So they're stressing that it is not to impede people from free speech. They don't have the means or the desire to regulate that. They're simply saying, based on the rules of conduct under the Code of Ethics, we can determine if you can be a member in this group. And by not being a member, and if we as the brokerage don't monitor our agents, which is a tough thing too, nobody wants that job. If we don't, then we as a brokerage can be sanctioned for it. So it's just strong encouragement to avoid putting things that can be inflammatory out in public media and making comments that could be anywhere from an ethics complaint to, you went beyond ethics, now you're into fair housing.
Yeah, I've seen, and this was of recent, within the past couple of weeks, I've seen some things on there. It has nothing to do with hate so much, but I've seen agents on there, and there was one in particular that had a T-shirt on, and if you read the word down, it was the F-bomb. But if you read across, each letter stood for another word, but it's just seeing that F-bomb on there, and that is an agent standing there with that picture showing that, and what does that say about your professionalism out there to the world? We got to be very careful in what we do and how we represent ourselves, because we are professionals, and we got to be very careful with that. There is a lot of attention being applied now to fair housing. I'm seeing it more and more. As I said, in my DC license, 3 of the 5 classes all touched on, and there was another class I was going to take that dealt with other things, and it all deals with fair housing. And if you want to deal with, take the DC exam one time. Here we have 1.5 hours of fair housing. DC is 3 hours, and it is so much regulated in DC. It's unbelievable. But there is, you all may have gotten it. I don't know whether you did or not, but you should have gotten it. There is a site out there. It came from NAR, and it's fairhaven.realtor. If you haven't been there, you should visit it. I took it 2 nights ago. I took it. It's like a class, and you click onto it, and it takes you about an hour to an hour and a half to go through, and it puts you in a bunch of different scenarios. 1 as a listing agent, 2 as a buyer's agent, 3 as a buyer, 4 as a seller, and it keeps on putting you through these scenarios. And there's not necessarily a right or wrong to it, but it puts you in those scenarios, and then it asks you how you respond and how you handle that, and you make a selection, and then it goes in and it will show you a video about it. And if we think that fair housing, discrimination, and things like that don't exist, there, and Shawn, you'll remember the name of it. There was a recent, they did something in upstate New York. Was it a year ago, 2 years ago? I remember when I was redoing my Delaware license, and Colin McGowan brought it up and put it on the screen. And they sent out a bunch of testers. They just went out into the community and hired these people to go out and be testers. And they went into all these offices, and how people are still being steered, how blockbusting is still taking place. It's very rampant. It's out there, and they're starting to pay attention to it. It's not uncommon for a tester to either call you to come into our office. Of course, it's not going to come into the office right now with COVID going on. But I know when the time when I was at LNF, and I'm going back a number of years, there was one that came into our office. And when they left, they called the manager. The agent did nothing wrong. The agent actually did the correct thing. They just called and let them know that they visited, that they participated in it, and that the agent did their job. But you are being tested all the time. You never know who's on the other side of that phone when you're talking to them. And it includes even directing people about school districts, because that now is considered steering. Okay? You don't want to go into that area because the schools aren't as good. That's not your decision. That's not for you to say. Everything is for them to look at. They ask you about demographics. That's not something you talk about. They can look all they want, but that's not something you are supposed to talk about. We sell homes. That's what we do. We sell homes, and we sell homes to everybody. I don't care what their background is, where they're from, what race they are, it doesn't matter. We sell homes, and we treat everybody equally. But that's it. I took it. It was a good test, and I'm telling you, I didn't get them all right. And it's called fairhaven.realtor. And you click on there, and it'll recognize, once you sign on, it's going to, you'll have your NAR sign on, and it'll take you right into it. And it takes a good, I did it at night, and it takes a good hour to hour and a half to go through the entire thing. But it was a worthwhile, it was eye-opening to me. And sometimes there were certain things so subtle that you wouldn't think that it would be considered a violation of fair housing.
I like you said, George, I shared with you, I've tried 3 times to start it and keep getting drug away, but I like the element that you shared, that it's helpful that they put you in the situation where they want you to be all 4 participants.
Yes.
Because it gives you a different perspective on how an innocent thing from you could potentially, if you were on the other side of the table or the pen, have a different interpretation innocently, but from different perspectives. If we all think about trying to think about it from other people's perspectives, there's enough going on out there. Be kind to each other, be kind to other people. I'm going to get off my soapbox, but we're bound to it by our code of ethics. So just, I think it's helpful to do an exercise where you get put into a situation where you're seeing something from somebody else's perspective. We're all open-minded people, or we wouldn't do this job. At least in this company, I can speak for it. So I'm going to make an effort to get it done.
Yeah, and keep in mind, the ethics doesn't just apply with the customer or clients or the general population that you're dealing with. It deals also with us as agents, how we treat one another. And that is something I have seen that has fallen in the way
yeah.
we treat one another.
And that's what got broadened a little bit in this change that they did in November. It used to be that you were sanctioned or observed only for your actions as a licensed realtor. That's not the case anymore. It's in all elements of your life. So anything that you do speaks to the industry, and that's what they're saying. As an industry, we have to be better with, for, to, about each other. So it's not just an action that you might do that's real estate related. It could be in your personal life that you're saying something. You are still representative of the industry. And so they broadened that, where it's not just real estate related activities and speech anymore. It's anything that you do and put out there.
Mm-hmm. Okay. Anybody else have any other questions? Anything that we're at? We got 14 minutes left. If you wanted, we can talk some more. If there's any questions you have, any topics dealing with ethics or anything like that? No? Okay. Well, I want to thank everybody for joining us today, and Shawn for expertise, and Wayne, it's always good to have, because you've got so much knowledge out there. We appreciate your input as well, and thank you guys. It's good to hear that, it's good to hear your questions, because that we don't know it all, and it helps us think.
George, I had a question.
Yes, ma'am.
Can you hear me? Okay, my question was, and I couldn't get in. I was trying to ask, but I didn't know how to do it. I want to know, how do you respond back to that thing when you were saying that they may, for the home inspection, they may say anything that the inspector may suggest? How do you answer that?
I usually call the other agent and I says, can you explain to me what this means? And a lot of times they don't know. Somebody told them to put that in there. I
Right.
said, my client, and it's always my client's decision, my client would like to know, be more specific. And if you can't be specific, I can ask them to take it out.
Okay, because I had one of those a couple months ago, and I just left it in, but then they didn't ask for anything else. So everything was fine. But I was just wondering how, so that's, you treat that, and you would not have your seller sign that.
No, I just explain it to them. I just present. I say, I see that this is, to me, I don't see a definite inspection here. How you feel about that? They may feel fine with it, and that's their decision. I just give them my 2 cents about it, and that's their decision. And they say, well, we would like a better understanding of what they're going to ask for. I go back to the agent, and then I'll go back to them and say, well, the agent says he doesn't know. It depends on the inspector.
So then you would scratch that?
No, I would ask them to. If that's what my seller asked me to do, that's what I'm going to ask them to do.
Okay, very good.
Negotiate it out. Say, or put something specific in there. Remember,
Hey, George.
yes, sir.
That's a good point there. I think a lot of the realtors just check it off just for the sake of checking it off, just to cover everything.
Sure.
And, a lot of times I'm thinking, you're kind of opening up a lot more situation. If you're concerned about something, then specifically say it. You want the chimney checked, you want the yard checked or whatever, then specifically say what you want. But they check that off just for covering it, and there's no reason for them to do that. And it does create a bit of a problem, as Pat was talking about, because now we're in a situation where we may have to, they're asking us for additional work to be done. I mean, we don't have to do it, but it could be additional work that we weren't expecting to.
I mean, I think of it in terms as like you got a loan commitment, and they put a time period in there, or they put in there, when will you have the home commit or the loan commitment? Someday. I just write in someday. It's so vague. I mean, what is that telling me? Yeah, or yes, we'll get a loan commitment. Well, when? Settlement. Well, as soon as possible. to be determined. I used to see that sometimes. Going back
Right.
years ago, I used to see that in them. To be determined. Well, what the hell does that mean? A contract has to have a beginning and ending date in it.
Yeah.
Put to be determined in there.
Right. Well, and that's the thing is, like, a lot of times these home inspectors are not roofers, and sometimes they say, well, I suggest having the roof inspected by a roofer. Well, you have certain time frames with to have that roof inspected, and it could easily go past that time, you know, because the roofer may not be able to get it out. And if you go past that time, you got 10 days, and you go past the 10 days, well, that roofer doesn't count anymore, because even though you wanted it, but we went past the 10 days, unless you asked for an extension. And I think that's where a lot of times you get in trouble, because the realtors forget to extend these things, realizing, oh, we're going to get a roofer out there. And the next thing you know, they don't realize they only got 10 days. Or actually only have 5 days left, because they had 10 days, or maybe they only have 2 days left, because they had 8 days to get the inspection done. You got 10 days to do it, and you got 2 days to get a roofer out there. And you know, that ain't going to happen. So that's, I think that's sometimes, you're right, George. I think what we need to do is specifically ask the question, why are you putting that in there?
Yeah, I just want specifics. And again, that's me. I want specifics. I want my seller or even my buyer to understand exactly what they're obligated to. That's my whole point. It doesn't mean that they're wrong by putting it in there. You may do that. I don't know. That's up to you. But I can tell you, if I'm on the other side, I'm going to ask for something more specific. Or at least I'm going to ask my seller or talk to my seller about it. My seller tells me, no, I'm fine with it. We're fine with it. I just need to explain it to them. That's all. It's like the as-is addendum. I explain to my seller when I get it, say, you know, they're saying as is, but it doesn't necessarily mean that. Let me explain to you what they might do. You know, you try and set up the scenarios. Everything we're doing is educating our clients. We're educating them in the transaction. I prepare their minds for it, because I find the more I prepare them for any obstacles they're going to be faced with, the more I prepare them, the more likely we will go forth with the contract, because in their minds, they're somewhat prepared for it. I'm not making them feel like something's really drastically going to happen, but this is the possibility. This is what they might do. Let's think about this. How are you going to feel if they come back and ask for this, this, and this? You know, be prepared for it. Yes, Shawn.
I was just going to say, my opinion, I don't like that statement, and I don't like it for other reasons, because if I'm working with a buyer, I would not put that in there, because typically, like you brought up, Jerry, it would be a roof, or it would be HVAC, or something specific that they want looked at. If you represent a buyer and you put that statement in there, with all due respect, that means your buyer is not going to pay for that HVAC person to come out or that roofer to come out. If you find a flaw in the home inspection and you write the property inspections notice, you're asking the seller to do those things with certifications at the seller's expense. So if you're representing a buyer, it's kind of, in my opinion, not a great idea to put that statement in there unless your buyer wants complete control over what inspector or contractor is going to come out to do the thing. If you're not doing as is and you're going to negotiate repairs, why not leave that statement off and let the seller do the incidentals that the home inspector wants further information on?
That's a good point, because the fact is that if you do a home inspection and the home inspector says, I think you should get the roof certified or inspected, let the home inspector make that determination in the home inspection report.
Right.
And let's probably get somebody else out there, because
Right.
we're going to get somebody out there anyway if they ask for it. So
So
that's a good point.
When I represent a seller, if I see that, my advice to the seller is, yeah, it could open up whatever, but they're going to pay for it. So that's the way I look at it. Yes, it does open up a potential can of worms, because like you said, it's like saying the word, it depends on loan commitment. It does potentially open up a whole slew of people coming in there, but still within that time frame and at the buyer's expense, not the seller's. So
Yep.
I don't think it's a great idea if you're representing a buyer to put that statement in there.
Right, yeah, because it puts it on to the seller. The seller would pay for the repairs or expansion if they want to do it or not.
Right.
Good point, good point.
Okay.
Okay. Any other questions? Guys, once again, thank you
you,
very
George.
much.
This is good, George. We
Thank
like it.
you.
Thank
Very
you.
good.
Guys, have a good one.
Have a good one.